Moi Wednesday confronted the Court of Appeal President William Ouko as he sought to be Kenya's next Chief Justice. Justice Ouko defended the decision, saying the aggrieved party had sued the former president in his personal capacity, yet the action was an act of the state and the Attorney General was supposed to have been involved. Let's take a look.
With about 34 years under his belt, Justice William Ouko started his legal practice in 1987, will put his best foot forward on Wednesday during the Chief Justice's interview. Justice Ouko has 17 years of administration in the judiciary under his sleeves, termed the failure to appoint the 40 judges or 11 who were to join the appellate court as a crisis.
Satisfaction amongst the public, but what is holding you back is those 11 judges, isn't it?
Yes, very true. My court has actually felt the brunt of this. If you graciously give me the opportunity, I'll come back to you. I'll come back to the commission. This is where it all started. To retrace our steps, to find out where the rain started beating us.
The panel, however, took issues with two owners received in 2 consecutive years, having chaired the body that was the same owners.
I realized that you got the Elder of the Burning Spear, EBS, in 2019, and also got the higher one, which is the Order of the Chief of the Burning Spear. Much as you may be deserving your honor, was this due to your membership of that committee, or how did that happen?
Why I ended up with the two. One, because it was realized that the honor that had been given earlier was lower than the level a judge ought to be given. Justice
Ouko had to defend the decision the Court of Appeal took in favor of the late former president Daniel Arap Moi, filed by one Mwangi Mureithi, who had claimed to have been detained and dispossessed in 1982, despite the late former head of state not filing any response.
Counsel for the former president, now deceased. And the Court of Appeal now went ahead, notwithstanding that there was no evidence to controvert what Mwangi Mureithi was saying. The Court of Appeal still went ahead and set aside, that judgment, and they filed in favor of the president, who had never filed any evidence, no affidavit, in as much as, of course, there was no viva voce evidence and all that.
But I know we were wondering why, in that case, why was the AG not sued? In the law, the president at the time, I do not think, if I recall well, had personal powers to do what he was being accused of doing. There was, I think, a committee that would do this, some security committee.
Also confronting the judge was the murder judgment of Murwa Atetu.
The first is, I think, paragraph 48, which I think people have misread. Paragraph 48 of that decision, the court says that you cannot take away discretionary powers of a court in sentencing by an act of parliament. So what I'll do, if you allow me to be the Chief Justice, because the Supreme Court did not finish its work. It gave an interdict. Have a mention and hear what the Honorable the AG has to say with regard to the assignment that he was given, now nearly 3 years, and you make a decision from there.
On Thursday, Professor Moni Wekesa will face the panel. For Channel 1 News, I'm Sarafina Robe.